Welcome back, everyone. We are moving into the second portion of our second pre-licensing session. We have Amy and Shelley presenting on the Introduction to Insurance from the Office of the Commissioner of Insurance. Please put questions in the Q&A, and if there is time, we may answer some questions at the end. Otherwise, we will share them out after the conference ends. Amy is an insurance program manager for the Office of the Commissioner of Insurance. She has been with OCI for a year, but has been working in the health insurance industry for 30 years. Prior to coming to OCI, she was a customer service supervisor at WEA Trust. Shelley is a health insurance examiner for the Office of the Commissioner of Insurance. She's been with OCI for 5 years, but in the insurance industry for 30 years. Prior to coming to OCI, she was a property and casualty underwriter for QBE Insurance. Amy and Shelley, please go ahead with your presentation whenever you're ready.
My name is Shelley Knorr. I'm with the Office of the Commissioner of Insurance. And this morning we are presenting our slide deck called Introduction to Insurance. Next slide, please. The Office of the Commissioner of Insurance was created by the legislature in 1870 and continues its works today, making sure that the insurance industry meets the insurance needs of all Wisconsin citizens. Next slide, please. OCI's mission has both a consumer component and a company component. In addition to helping consumers navigate the insurance marketplace, we also ensure companies are healthy from a financial perspective in terms of having reliably compliant business practices. This helps ensure that Wisconsin consumers continue to have plenty of dependable choices. Next slide, please. We serve as a resource for consumer, insurers, and agents on a practical level. We also monitor market activity for misleading or deceptive practices. We help consumers connect with resources for help in making new enrollment choices. And will investigate consumer complaints to ensure that substantiated complaints are referred to our legal unit for possible administrative action. Next slide, please. In 2022, there were 2,044 insurers authorized to write business in Wisconsin, with 329 of those being domiciled or located in Wisconsin. There are over 214 agents licensed to do business in Wisconsin, and over 34,000 of those are Wisconsin residents. In 2022, OCI investigated and resolved 2,678 written consumer complaints and handled over 19,000 general inquiries received via email and telephone. Lastly, we assisted complainants in recovering over $9.2 million from insurers. Next slide, please. Some of the duties and powers of our office are to protect and educate the public and to ensure that the insurance industry meets the needs by being responsible, adequate, and even-handed. Next slide, please. The Commissioner shall administer and enforce the insurance chapters and shall have all powers specially granted or reasonably implied to enable the Commissioner to perform the duties to administer and enforce the statutes and regulations. Those considered doing business of insurance are regulated and require a certificate or license. Also, the Commissioner is granted the authority to require responses of licensees. The Commissioner also has the authority to require from any person subject to regulation under Wisconsin insurance law, such as agents, insurers, navigators, and agencies, the following: statements, reports, answers to questionnaires, and other information in whatever reasonable form the Commissioner designates, and at such reasonable intervals as the Commissioner may choose, and a full explanation of the programming of data processing systems, computer systems, or any other information storage system or communication system in use. The Commissioner may recommend forms for the reports and specify who must execute or certify them. The Commissioner may require verification of any report. Lastly, the Insurance Security Fund was established to provide certain protections to insureds in the event of an insurer's liquidation. Money in the fund comes from assessments against all insurers, with some limited exceptions, licensed to transact business in this state. The fund is administered by a board of directors to include the Attorney General, the State Treasurer, and the Commissioner of Insurance. Next slide, please. The Commissioner is granted broad authority to regulate the insurance industry by balancing consumers, insurers, and legislative requirements. The legislative note to the introductory section of the insurance statute states insurance is an area of free contractual activity, except as restricted by the Insurance Code. This freedom to contract allows a free marketplace and the responsibility of OCI to monitor the marketplace to maintain a level playing field. Next slide, please. There are three key pieces of this statute: the balanced solvency of insurers, fair and equitable treatment of the insured, and the legislative direction and oversight. The ability, to have the ability for freedom of contract and freedom of enterprise requires a level playing field and accessible and understandable contract terms. The purpose is to provide for a full office that is an expert in the field of insurance and has the authority to enforce chapters 600 to 655 of the Wisconsin statutes, encourage full cooperation of the office with other regulatory bodies, both of this state, other states, and of the federal government, improve and thereby preserve state regulation of insurance, encourage encourage self-regulation of the insurance enterprise, and encourage loss prevention as an aspect of the operation of the insurance enterprise. Next slide, please. Enforcement by state agencies is conducted through an administrative proceeding. A neutral judge hears the facts and evidence and renders a preliminary decision, with the final decision issued by the Commissioner. Because the Commissioner is the final adjudicator, they are walled off from matters that may be contested, but they are fully engaged. Whenever a person fails to comply with an insurance law, regulation, or order, the Commissioner may start a legal action directing the person to comply with the Commissioner's order and restraining that person from further noncompliance. In addition, forfeitures, license revocation, suspensions, civil penalties, and criminal sanctions may be leveled by the Commissioner. The Commissioner must hold a hearing before issuing an order or rule whenever the insurance laws or the administrative procedure requirements expressly provide for a hearing. Unless the insurance laws prescribe special procedures, all hearings must comply with the procedures set out in Chapter 227 of the Wisconsin statute and Chapter 5 of the Wisconsin Administrative Code. The statutes do provide for the summary suspension of an intermediary or navigator's license if the Commissioner finds that the public health, safety, and welfare require such emergency action. If the intermediary or navigator fails to pay a fee when due or fails to comply with continuing education requirements, the Commissioner may revoke the license without a hearing. Also, a license must be revoked if the intermediary or navigator is liable for delinquent taxes or unemployment insurance contributions as certified to the Commissioner's office by the Wisconsin Department of Revenue or the Wisconsin Department of Workforce Development. Next slide, please. One section within the Division of Market Regulation is agent licensing. The agent licensing divisions has four main parts: the licensing of insurance intermediaries, regulation of insurance marketing practices, compensation of insurance intermediaries, and the licensing of regulation of navigators and non-navigator assisters. The licensing of intermediaries and navigators is concerned solely with the qualifications of the person applying for the insurance license. The essential requirement is that they must be competent and trustworthy. The competence includes a basic understanding of fundamental insurance law as well as knowledge concerning specific statutes and rules. Wisconsin insurance statutes outline and define the general requirements which the insurance intermediary must follow. In addition, the insurance intermediary must understand and follow the administrative code which has been adopted by the Commissioner. General statutory language is expanded and clarified, describing for agents and companies the practices that are allowed and or prohibited. These rules must be and will be strictly enforced by the Commissioner. Next slide, please. So when is an insurance license required? Simply put, in most instances, a license is required when a person is doing the business of insurance. Persons may be exempt if the functions they perform do not require special competence or trustworthiness or to achieve other purposes that are stated in chapters 600 to 655 of the Wisconsin statutes. Regulatory surveillance is made possible by licensing. Next slide, please. So here are some scenarios in which a license would or would not be required. So under scenario number 1, this is a person who incidentally advises other persons about insurance needs and coverages during the normal course of his or her non-insurance related business and who receives no direct or indirect compensation on account of any transaction which results from the advice. So, in this scenario, the answer would be no. This person comes under the exceptions listed in Statute 628.02 and is not considered an intermediary. The second bullet point is a person who places insurance for an insurance company or on a door to door basis. Yes, again, under Statute 628.02, this person is an insurance marketing intermediary and is required to have a license. And lastly, a person who advises other persons about insurance needs and coverages and is directly compensated by an insurance company or the insured. Again, the answer is yes. Under 628.02, this person is also again considered an insurance marketing intermediary and is required to obtain the license. Next slide, please. The definition of risk relating to insurance is the uncertainty of a financial loss. Risk tolerance is the amount of risk one is willing or wanting to take on by themselves or can afford to take on for themselves. Insurance is defined as a transference of risk. One pays the insurance company to take the financial risk from you to them for a fee called a premium. Typically, the more risk you transfer to an insurer, the higher the premium is for the product, as the potential for loss is greater. Often you will see lower premiums with group products. The reason for this is the law of large numbers or pooling of risks. The insurance agreement is a contract and governed by contract laws. The basic elements of a contract are an offer of coverage, acceptance of the coverage, consideration, or also known as the money, and an intention to create a legal relationship. Once entered, a contract is enforceable. For example, you've identified an insurer offering health insurance and you have selected from the available options to purchase. You reviewed the policy, also known as the contract, to ensure that after you pay any member cost sharing, the insurer will pay the remainder as defined under that contract. During the period, which is typically 1 year, you will look to the insurer to fulfill its obligations. Next slide, please. Excuse me. The laws and regulations in our chapters apply to all insurance policies delivered or issued for delivery in this state for the following: persons residing in Wisconsin when the group or policy certificate is issued, property ordinarily located in Wisconsin, or business operations in Wisconsin. Regarding the readability of policies, INS 6.07 establishes the minimum standards for legibility, coherence, and understandability in consumer insurance policies on a scale of 0 to 100. If it scores 100, it is easily understood by the average 11-year-old. But if it scores a 10, it is very difficult to read and best understood by university graduates. And there are obviously many levels in between the 0 to 100 as well. Is a notice to an agent notice to the insurance company? Yes. The insurance company has been notified if the company's authorized agent has been notified by or on behalf of the policyholder or insured and provided with sufficient information to identify the policy in question. Every insurer is bound by an act of its agents performed in Wisconsin that is within the scope of the agent's authority. The insurance company remains bound while the agency contract is in force or until the insurance company has made reasonable efforts to recover from the agent its policy forms or other documents from the agency. An insurance company is deemed to know any fact material to the risk or that violates a condition of the policy. If the insurance company's agent who transmitted the application to the insurer knew the fact at the time he or she acted, or if afterwards any of the company's agents learned of the fact during the course of dealing with the policyholder as an agent, and knew of that fact pertaining to the eligibility of the policy. Misrepresentation by an intermediary is the use of written or oral statements which incorrectly describe the terms or benefits of any policy. Representations are oral or written statements made by an applicant. Insurance coverage is issued on the basis of the applicant's representations. A material representation is an untrue statement made by the applicant that could influence a prudent insurer in determining whether to accept the risk or in fixing the amount of the premium in the event of such acceptance. Wisconsin consumers are provided with privacy protections for medical and financial information. These laws correspond with the requirements under the Federal Health Insurance Portability and Accountability Act of 1996, also known as HIPAA, and the Gramm-Leach-Bliley Act, enacted in 1999. Chapter 25 of the Wisconsin Administrative Code addresses insurance agents' responsibilities when sharing consumer and customer private, personal, financial, and health information with third parties. Insurance agents may, for the most part, rely on the insurance companies with which they are listed to provide the required notices and disclosures. Wisconsin also enacted a statute that regulates the disclosure of personal medical information. It places restrictions on both insurers and the persons that regularly assemble or collect personal medical information for the primary purpose of providing the personal medical information to insurers for that determination of an individual's eligibility for a health insurance coverage, benefit, or payment, or servicing of an insurance application, policy, or certificate. The rule also establishes restrictions on the sharing of health information. In addition to health information, Wisconsin enacted rules that require insurance companies and agents to provide written notice of its privacy policies and practices. The rule describes the conditions under which insurance companies and their agents may disclose non public personal financial information. The rule also establishes requirements for privacy notices. And lastly, the right to file a complaint. Yes, insurers are required to notify their insureds of their rights to file a complaint with the Office of the Commissioner of Insurance regarding any problems they may have with their insurance. This notice is required once for each policy or certificate issued by an insurer. Next slide, please. So we've come to our first polling question. True or false? An insurance agent is bound by the acts of its let me try that again. An insurance company is bound by the acts of its appointed agent when the agent acts within the scope of their apparent authority, even if they do not have an actual authority from the company. So, again, true or false? Okay. So, correct. The answer is true. They are bound. Sorry, we'll give everybody another second here. But yes, they are bound. The company is bound by the acts of the agent, regardless if they actually have an appointment with that company yet or not. So let's do next slide, please. So with regards to insurance contracts, regarding the notice of claim, proof of loss is to be furnished to the insurer as soon as reasonably possible and within 1 year after the time it was required by the policy. An example of this would be for, let's say, submitting a prescription cost receipt in a timely manner for something you had to pick up while on vacation once you return home. For prompt settlement of claims, unless otherwise provided by Wisconsin law, subject to an interest payment, an insurer must promptly pay most insurance claims within 30 days after receipt of all the information that they need to properly process that claim. And as for a mistake, what is the legal effect of a mistake in an insurance contract? In most circumstances, unless otherwise provided, general contract law applies to mistakes in insurance contracts. For example, let's say in property insurance, a mistake was made in designating the person to whom the insurance is payable, but that does not void the policy. Such a mistake does not constitute a defense for the insurance company unless the mistake was due to misrepresentation or concealment by the owner of the property. Next slide, please. What are some examples of unfair claims settlement methods and practices? The failure to promptly acknowledge pertinent communications with respect to claims arising under insurance policies, the failure to promptly provide the necessary claim forms, instructions, and reasonable assistance to insureds and claimants, the failure to attempt in good faith to effectuate fair and equitable settlements of claims in which liability has become reasonably clear, and knowingly misrepresenting to claimants pertinent facts or policy provisions. Each line of insurance has a period of time for which a consumer can return the policy without any penalty. Life insurance, for example, is a 30-day after delivery for a full refund when the new policy is sold is a replacement of an existing one. For health insurance, a policyholder may return any individual health policy within 10 days after receiving it. If the policyholder returns the policy within that period, the insurance contract is invalid and all payments made under the contract must be refunded. The right to return provision must be printed on or attached to the first page of an individual policy. Although an insurer may cancel a policy for non payment of premiums, a consumer is entitled to a grace period for the payment of any premium due. During this grace period, coverage does continue. Per state law for health insurance policies, it is not less than 10 days for weekly premium policies, not less than 10 days for monthly premium policies, and not less than 31 days for all other policies. A consumer should always check their policy to see if their insurer includes a grace period provision. The Marketplace Affordable Care Plans will have a different grace period, though, depending on whether or not the consumer or member is receiving the advanced premium tax credit or not. Next slide, please. Here are some examples of some plans that, in general, do not fall under the jurisdiction of our office. Self-funded ERISA plans are typically large employers that are governed primarily by the U.S. Department of Labor. But when a state law or regulation is related to the business of insurance, the state may retain jurisdiction over that piece of the plan. There are a few self insured employer plans that do fall outside of the federal jurisdiction as well, such as self funded non federal governmental plans and church plans. Labor union and employee welfare plans are also governed by the U.S. Department of Labor. Discount plans provide discounts on medical procedures with certain doctors or medical related costs, such as prescriptions, just like using a coupon at a store. These plans are not health insurance plans in the traditional sense. Medicare Advantage plans are the federal government's version of a Medicare HMO. The Centers for Medicare and Medicaid Services, also known as CMS, directly contract with insurers to provide the Medicare benefits. States have negotiated, though, and retained jurisdiction over the agents as they are licensees. Medicare Part D are the prescription drug plans that are sold separately from Medicare, supplemental insurance plans, or traditional A and B coverage by the feds. Healthcare sharing ministries were the original form of a GoFundMe account. In Wisconsin, there is an exception for members of a denomination or organization that agree to help financially support fellow members. The member is required to pay any medical bills first and then post their needs in a newsletter for other members to be able to donate funds to help offset that individual's expenses. And then lastly, direct primary care is reemerging from the past. This typically primary care internist or family practitioners directly negotiate with consumers. The OCI does monitor these offerings as frequently there is a component of risk transfer. Next slide, please. So we've come to a portion, maybe just a little quicker than I had hoped, so I apologize for that. But um, let's do a 10-minute break. And can we all please be back here by 11:10 a.m.? Thank you.
Welcome back, everyone. This is Amy Sather from the Office of the Commissioner of Insurance. We'll get back to our slide presentation. Limited benefit plans and other products may be marketed in a way that looks like an alternate ACA product. Fixed indemnity health insurance is a type of medical insurance that pays a predetermined amount on a per period or per incident basis, regardless of the total charges incurred. These types of plans do not provide coverage for essential health benefits, can exclude pre existing conditions, and have annual and lifetime benefit limits, as well as defined benefit limits for all services, as that's their service model. Here are some of the key practices OCI monitors. Some examples of these are the following: unfair marketing practices, which includes misrepresentation, restraint of competition, and choice of insurer. Misrepresentation, which includes omissions, misleading, and false entries. When an intermediary, their employees, or those acting on their behalf make a written or oral communication about any insurance contract, the insurance business, any insurance company, or any agent which contains false or misleading information. Restraint of competition, which includes boycott of an insurer and intimidation. Choice of insurer includes requiring a purchase of insurance as a condition of a contract not related to insurance. If insurance coverage is required, the consumer's right to select an insurer provide. Excuse. If insurance coverage is required, the consumer's right to select an insurance provider and or agent cannot be restricted. Home solicitation sales must include clear statements on the intent to sell insurance as part of the visit, where the solicitation or sale is made by an agent at the residence or place of business or employment of the buyer, or away from the agent's regular place of business. Home solicitation selling includes solicitations made directly or indirectly by telephone, person to person contact, or written or printed communication, other than general advertising that indicates intent to sell insurance or services at a regular place of business. Prospective buyers of disability insurance must be provided with clear and unmistakable statements, explanations, advertisements, and written proposals concerning policies offered to them. This includes printed and published material, including the internet and web pages, social media pages, including social networking websites, descriptive literature and sales aids of all kinds issued by an insurer or agent for presentation to members of the public, prepared sales calls, presentations of material used by the intermediaries, and representations made by agents in accordance with these talks and exhibits. Advertisements and representations must be truthful, not misleading, and must accurately describe the policy to which they are applying for. Please note that an advertisement means printed as well as oral representations. Advertisements may not directly or indirectly make unfair or incomplete comparisons of policies or benefits. Lastly, advertisements may not falsely or unfairly disparage, discredit, or criticize competitors, their policies, services, or business practices. OSI will have staff looking at websites, media posts, and mailings. We will be responding to complaints on any of these issues. Phone calls and applications taken by phone, If the application was taken over the phone by an intermediary per the Wisconsin Administrative Code indicated on the slide, it specifically requires the agent to keep the application for 3 years. That is considered a record even if taken over the phone or conducted online. For e-delivery, if an oral communication or recording of an oral communication can be stored and reproduced, then the oral communication may qualify as a notice or document delivered by electronic means. Companies are required to file forms with us under 631.20 of the Wisconsin statutes. The definition of form includes application. The insurers must keep copies of these filed forms per Wisconsin Administrative Code 6.05. If a company didn't file an application with OCI as a form, they cannot rescind the policy for material misrepresentation on the application because the application would not be considered part of the policy. Plus, they don't have a copy of the application, so they can't establish misrepresentation. For electronic online applications, we view the screen as a type of form, and we would expect to be able to review that form. OCI will monitor for marketing tactics that steer enrollees to non-ACA compliant products, such as short-term limited duration and healthcare sharing ministry. Here is our second polling question of the day. Which of the following insurance is generally exempt from OCI jurisdiction? Please select the appropriate plan or insurance that is exempt from OCI jurisdiction. You'll have approximately 30 seconds to make your selection. It looks like most everyone has made their selection. D is correct, all of the above. Here are here are the common federal laws that can impact health insurance. Medicare is a broad program of health insurance designed to assist the nation's elderly to meet hospital and medical and other health costs. Medicare is available to most individuals 65 years of age and older. The Employee Retirement Income Security Act of 1974, also known as ERISA, is a federal law that sets minimum standards for most voluntarily established retirement and health plans in private industry to provide protection for individuals in those plans. COBRA gives workers and their families who lose their health benefits the right to choose to continue group health coverage provided by the group plan for a limited period under certain circumstances such as a voluntary or involuntary job loss, reduction in the hours worked, transition between jobs, or other life events. Qualified individuals will be required to pay the entire premium for the coverage. The Mother's Health Protection Act, or otherwise known Newborn Act, includes important protection for mothers and their newborn children regarding the length of hospital stay following childbirth. This requires group health plans that offer maternity coverage to pay for at least a 48-hour hospital stay following childbirth or 96 hours in the case of a C-section. The Women's Health and Cancer Rights Act of 1998 is also a federal law that provides protections to patients who choose to have breast reconstruction in connection with a mastectomy. This law applies generally both to persons covered under group health plans and persons with individual health insurance coverage. HIPAA was developed in 1996 and became part of the Social Security Act. It set national standards to protect individuals' medical records and other personal health information. It gives patients more control over their health information, and it sets boundaries on the use and release of health records. Mental Health Parity and Addiction Equity Act, or MAPIA, provides group health plans that offer mental health benefits from imposing more restrictive annual or lifetime limits on spending for mental illness than they are imposed on the coverage of physical illnesses. The Affordable Care Act, or the ACA, ensures that all Americans have access to quality health care that is affordable. It eliminated the pre existing clause that prohibited some consumers from being able to purchase a quality healthcare plan. Lastly, the Federal No Surprises Act was effective for services received after January 1st, 2022. This protects the consumer from surprise bills for emergency services from out of network provider, facility, and air ambulance providers. No, ground ambulance is currently not covered under the NSA. The cost sharing amounts for all emergency services should be at the in network rate. It also provides protections of out of network charges and bills for supplemental care, like radiology or anesthesiology, by the out of network providers that work at in network facilities. Medicare is a federally funded and regulated program under the U.S. Department of Health and Human Services. Medicare is available to most individuals 65 years of age and older. Although folks with end stage renal disease are eligible for Medicare, there is also a state mandate for coverage of kidney disease. Wisconsin is an exempt state from the federal Medicare supplement products, which I'll explain further in the next slide. Wisconsin is a waived state, which means we provide a different kind of Medicare supplement policy, not labeled with letters. Medicare supplement policies in Wisconsin have set minimum comprehensive requirements for supplemental coverage. Individuals have 6 to 7 rider options available that must be separately priced from the base coverage. Some examples of these riders are foreign travel, Medicare excess coverage, and inpatient deductible coverage. If a consumer comes to you stating they are being quoted a supplemental plan with a letter name, advise them to make sure this is a Wisconsin plan being quoted and not one based in another state. Insurance companies sell policies referred to as Medicare supplement policies to fill coverage gaps left by Medicare. Medicare was never intended to pay 100% of a person's medical bills, but was created to offset medical expenses, providing basic foundations of benefits. Medicare requires a person to pay deductibles, and many Part B expenses are paid at 80% of the Medicare approved amount. Insurance companies have the right to ask for additional information or documentation to help adjudicate a claim. Consumers may need to become involved with the process of assisting in obtaining this information from their provider if there seems to be a disconnect between the company and that provider. Non-renewal of a policy refers to the termination of a policy at the expiration date. If an insurer decides it does not want to renew your policy, it must mail or deliver to you a non-renewal notice at least 60 days before the policy expires. The non-renewal notice must be clear and concise to the consumer and cannot use general terms. Reasons that are not acceptable under this definition would be condition of property, damage to vehicle, coverage not offered. This slide pertains specifically to midterm cancellations. Nothing is official until a consumer has been given 10 days notice. This notice could be provided by email, assuming that there is language in the policy informing an insured of this and that the insured has agreed to this method of delivery ahead of time. The Court of Appeals in Wisconsin has ruled that when the Postal Service, the Court of Appeals of Wisconsin has ruled that when using the Postal Service to mail a cancellation notice, the written notice to the policyholder refers not to the receipt by the policyholder, but to the date the notice was mailed by first class mail, as permitted by statute. Often, short term limited duration plans with limited coverage, pre existing condition exclusions, limited provider networks include unnecessary or unwanted benefits that appear included or free but actually just pad the cost to the consumer or add junk fees. Other times, the companies are health care sharing ministries that are not licensed or authorized to sell insurance products. There are legitimate healthcare sharing ministries that operate under a federal exemption, but there are a lot of bad actors cloaked as healthcare sharing ministries, taking money from people and not paying benefits. There could be situations, not altogether of fake products, but misleading. Misleading, even by omission, is a violation of Wisconsin insurance law. Consumers search the internet for health insurance, Obamacare, Marketplace, Trump Care, etc., and are directed to websites enticing them to enter contact information to receive rates. Unauthorized use of logos of well known companies given an illusion of legitimacy and lead the customer to believe they will receive information on coverage with these carriers. The text falsely and misleadingly referenced the state of Wisconsin in the context of recently approved or new insurance programs. If you know someone has fallen for a scam, don't wait. Have them file a complaint with OCI. If it does not fall within our jurisdiction, we will refer the issue to DATCAP or the appropriate agency or jurisdiction. Anyone has the right to file a complaint with our office, and insurers must notify individuals of that right. That information is located on the Wisconsin Administrative Code 6.85. The Consumer Affairs team at OCI is dedicated to protecting and educating Wisconsin insurance consumers. A complaint must be filed in writing to allow for their side of the story to be presented to the insurance company, agent, pharmacy benefit manager, or medical provider. Wisconsin Open Records Law was enacted in 1982 and is a series of laws designed to guarantee that the public has access to public records of government bodies at all levels. When you file a complaint, that becomes an open record once the complaint is closed. Generally, any person may make an open records request, but there are some restrictions. We make all efforts possible to protect a person's private, financial, and health information. Electronic complaint forms are available on our website to submit directly to our office. Here are some of the questions that a health insurance examiner asks themselves when reviewing a company or agent response to a complaint. At OCI, we want the problem resolved within the guidelines of the insurance laws and statutes and do not want to see the problem continue, in addition to making sure a consumer was not harmed or wronged in any situation. On our website, we can also try to educate consumers prior. On our website, we also try to educate consumers prior to submitting a complaint on what they can expect from our agency. The company, agent, pharmacy benefit manager, or provider response should provide us with a clear and detailed picture of the event surrounding the complaint and what, if any, resolution can be provided to assist this situation. We try to educate consumers on how their insurance policies work by providing publication and links to other documents and websites. We also try to educate consumers upfront on situations that we cannot handle and to suggest consulting with an attorney about their specific rights. The main issue a health insurance examiner may run into is being asked to make a medical determination. We are not healthcare professionals and we cannot read medical charts or doctor's notes to make an assessment. Medical necessity is a term in an insurance contract itself, and the Wisconsin law does not define medical necessity or mandate the criteria that insurers must use to determine it. Each insurer establishes its own criteria for determining if a particular service or treatment is medically necessary. We also cannot assist in determining what a consumer feels is the right amount of money to make them whole again. There are times when we don't have jurisdiction in a matter, as we've touched on earlier. We will refer a complaint to the proper entity for review and assistance. We must remain a neutral party in all complaints. Our role is to ensure that our state laws and statutes have not been violated, and then in case of the insurance company, make sure they have followed the terms and conditions of their members' policy. And here is a list of resources available on the OCI website. Thank you for joining us today for this presentation.
All right, I think we will hold for some questions. If anybody has any questions, they can go ahead and put them in the live Q&A. All right, we'll do a little bit longer for any questions. All right, so doesn't look like we have any questions. So what we are going to do is we will end just a little bit early today. So we will see you all tomorrow for our third pre-licensing session, and we hope you all have a great day.